Good evening. This is John Milburn for Laws 12062 Alternative Dispute Resolution. We're into week 10. We're getting close to the end now, and the take-home exam in 2 weeks. We'll talk about that next week. But first, I'd like to talk about the first assessment piece. Overall, I was very happy with the work that students presented to me. I trust that you've now received your feedback in relation to it. If you have any questions about that feedback, please feel free to ask or send me an email if you wish. By all means, you can record any notes by a conversation in UCrew as well. So I want to speak briefly in general terms about the feedback and the work that I saw. Overall, work was very good. Remember the aim that I advanced at the outset of the course, and that is when you're acting as the ADR practitioner, you are there to assist and persuade, to acknowledge that the parties are likely to be in a very stressful situation and a stressed state. They're likely to be looking for someone to assist them to resolve the dispute. They're there in the ADR session because they don't want the dispute resolved for them. They want to participate and come to a resolution. So one of the important things that I looked for during the course of marking the assessment was an answer to this question. Did you, as the ADR practitioner, allow the parties to retain ownership of their own dispute? Or did you create a situation that was not what I believe to be the appropriate manner for mediation or conciliation, and did you attempt to adjudicate the matter? In order to encourage the parties to negotiate, you need to create an atmosphere that allows them to do so safely, to make them feel, to borrow from Professor Ashman, as if you have become their new best friend. You need to adopt a lively, dynamic approach. Now, when I started to mark the assessment, I formed a preliminary mark almost immediately within the first few minutes. Now, you might think that's unfair, but bear in mind that given the mediation session was there to persuade, to assist the parties, the first impression is very important. And to be honest, how many times have you formed an opinion of someone, or an impression at least of someone, based on the first few minutes of speaking with them? Now, I'm not suggesting that I looked only at the first few minutes and that was the mark, far from it. But it was an important, and it set, in my mind at least, an area of where this student is likely to be in the continuum of marks. So having a good opening, I think, is very important from the persuasive perspective. And of course, you then need to work very hard in terms of listening carefully, engaging with the parties. You don't have to be loud or eccentric or anything like that, but what you need to do is allow the parties to focus their attention on their dispute and focus on each other as much as possible. Some students dominated the process, in my view, far too much. I don't mind in a mediation session if, as a result of trying to sponge emotion or to elicit information or to reframe and detoxify, if in those circumstances much of the attention is on you as the mediator. And you can actually direct parties to come to you if you feel that there is some good advantage in doing so. But the art of mediation conciliation requires you to allow the parties to focus their attention on each other. In practice, what I do is a bit of body language. If I've reached the stage where I do want the parties to engage with each other, then when they come to me, I'll often use a gesture, which is a look away with a hand motion, as if to say, don't tell me, tell the other side. And people respond to that very well. The other thing that I do is, we use silence to good effect to encourage people to speak. Sometimes, despite everything I've said about the advantages of maintaining good eye contact, after having established the good eye contact, the good connection, when I want the parties to speak to each other, I will often intentionally look away, distract myself, as it were, on my computer or my notes. And that in itself encourages parties to start talking with each other. I don't want them to do that at the start. I want them to engage with me and likewise. But there comes that time when you should do that and allow the parties to focus and retain ownership of their dispute. So all of this is part of your role in, if you like, coaching and assisting and providing some degree of reality testing and setting a scene to allow the parties to speak with each other. Now, some mediators in their session asked a lot of closed questions, which is essentially like a cross-examination or an examination in chief type situation. Cross-examination. So in a mediation session, you want to ask open questions that allow parties to explain the situation. So the purpose of your question is to elicit information rather than to make assumptions and put it to the parties that this was the case. So if you were asking closed questions, I'm sure that I would have marked you down as a result of that at the start. So certainly you need to take control, but you need to do so in a way that is in control of the process rather than in control of the dispute itself. So there's some of the things that I was looking for. Obviously, you've got to set the scene, be confident, build the rapport, build the trust that we're talking about. Some parties provided a very good opening where they were clearly well prepared, and those that were most well prepared were able to provide the opening in the most relaxed and informative manner. Those that were perhaps a little less prepared or less confident read their material, and that's not a great way to start a mediation session. So if you weren't using notes, I'd encourage you to do so and build this as part of your toolkit for later use beyond this subject as well. Obviously, I was looking for people to explain the process. Most people did that, explain confidentiality, the length of the process, no interruptions, some rules in relation to housekeeping, authority to settle and resolve the matter, no previous communications with the parties, perhaps explain who's going to speak, no interruptions, etc. Most people did that pretty well. And I was looking to see if people were engaging and attentive to the parties while they were doing that. Some mediators focused their attention on one party, not the other, but those that didn't do so well in the opening focused their attention not on either of the parties, but on their notes or themselves. So once we get into the opening statements, we're looking to ask open, clarifying questions. And to do so appropriately, keep the questions short, avoid the double-barrel questions. Some parties spoke for too long, in my view, which stifled the conversation and took from the parties and made it more about themselves than ought be the case. So friendly, open, communicative style, ask clarifying questions, ask open questions, make them short, make them single questions, and then allow the parties to move on. Obviously, I wanted to see equal balance and attention between the parties. And I was very keen to see people keep the parties in a joint session. There were a few instances where people were doing well. I thought they've got a great opening. They've connected with the parties. They have formed a real bond. And everything points to the fact that now the parties will start to engage with each other. And just at that moment, they say, well, now's a good opportunity for us to go into private sessions. And you could hear me screaming on the other end of the camera, why are you doing that? This is a great opportunity to engage with the parties with each other, give them a chance to own their dispute. You're taking the dispute away from them. I know that some mediators adopt a style where they almost immediately and invariably go into private session. I certainly don't subscribe to that theory. If you did go into private sessions too quickly, then you probably got some feedback from me to that effect. But just generally, part of the reason I don't like it is that it takes the dispute from the parties and it puts you in a difficult position. You now become a broker. You become a person who, instead of encouraging dispute to be resolved between the parties, ferries offers between one party to the other, just like a real estate agent might in trying to put together a deal. And we don't really want that. It puts you in a situation where you might be under fire down the track if something goes wrong, on the basis that you didn't put that offer to the other party accurately, as if you're acting for the party, that you're their advocate. Do you understand some of the concerns that I've got? All right. Most dealt well with power imbalances. Some were put in a position where the parties became very animated. At the early stages, I don't mind if you let them go a bit. I actually marked down those mediators, conciliators that jumped on the parties, in my view, too quickly. What's wrong with jumping on the parties if they're becoming animated and a bit excited? Well, you run the risk of taking the dispute from them, and you run the risk of them saying, I've come here to have my say, and just when I'm getting warmed up and I'm just saying what I really mean, I'm shut down and I'm told I can't speak. So what's the point? And they become disengaged. So to some degree, when the emotion steps in, you need to allow that to flow, even if it means sponging it yourself. But don't be too quick. And practice your reframing skills. So if you see some emotion, some comment that is derogatory, instead of immediately shutting it down and panicking and saying, all right, none of that, and sort of speaking over the top of them, I told you that we're not going to interrupt and we're going to respect each other. I mean, a little bit along the lines of you doing exactly what you told the parties not to do. What you can do is, or panicking and going into private sessions and say, all right, well, obviously we're all getting heated emotion. I think now's a good time to go into private sessions. We've separated them. Now as a mediator, I'm a bit safer. Take on the challenge, embrace the challenge. And so if one of the parties says, that idiot next door is always playing his stupid music too loud at all hours of the expletive day and night, rather than panic, separate the parties and tell them to stop using bad language, maybe you just go with it a bit and say something like, therefore, the noise levels and the time of day are both important issues to you. Is that correct? Oh, yeah. Okay. So now the party, you'll see them, they'll just sort of drop a bit and go, okay, well, you've heard me. Yeah, they are they are the important issues. So then you're talking less about the parties, you're talking more about the issues, and that's your reframing skills. And it allows you to allow the parties to retain control of the content and you maintain control of the process, which is really what I was looking to see. And using that reframing exercise that I mentioned just a moment ago also allows you to convert those positions that the parties have into their interests and joint interests about, it's a good neighbourhood, let's see what we can do to make it enjoyable for everyone to live in the neighbourhood well. So it's all part of encouraging direct communication. Sometimes some mediators did well. They actually, if there was a little breakthrough, congratulate the parties. That's excellent. All right, so we've come to agreement on a few important points. Let's see if we can move on to discuss some of these issues. Some mediators went straight into brainstorming, and I like brainstorming. I like to engage the parties in trying to help you to come up with some solutions, because sometimes the parties are very good at doing that. Invite them to brainstorm, but I wouldn't do that straight away. I think you've got to go through some clarifying exercises first to understand their position and to convert that position into appropriate issues. All right, so some of the things that people did well: enthusiastic, asked short, clarifying questions, remained focused, went with the flow a bit, allowed the parties to discuss with each other, and encouraged them to retain ownership of the dispute. Have a look at your own video and ask yourself some of the questions that I'm about to go through now, with a view to learning how to improve in the future. Did you appear disinterested, or did you appear to lack capability? Was there a confidence issue? Were you looking down at your notes? Were you using a sort of slow and unimaginative approach? Were you uncertain, stuttering, or uninspiring? Did you take the dispute from the parties? Some of the hallmarks. Did you speak too much? Did you display controlling behaviours? Were you too much of a headmaster or headmistress? Did you ask closed questions, effectively subjecting the parties to some sort of cross-examination? Did you actually encourage and ask the parties to focus their attention on you all the time? Fine at the start, but there's got to become a time where you start to get them to focus on each other. One hallmark is throughout the process, all questions and all answers go through you. We saw that a lot with some mediators. Almost every question, it was through the mediator. Didn't create that link between the parties. And did you show signs of bias? I think overall that was good. People didn't do that. And did you retain control of the process? So if the parties started to talk to you and you want them to talk to each other, think about some of those techniques that I've mentioned tonight to do so. Okay, so that's a very brief overview of my thoughts in that marking process, and hopefully you've had a chance to read your own individual comments. Are there any questions? All good? Okay, thank you. Now let's talk about ethics. Okay, so where do we look as lawyers for guidance in relation to ethics? What are the two most important documents?
Solicitor's rules.
Oh, sorry.
Two people coming in.
Sorry.
No, you're right. So firstly, we've got the solicitor's rule. Who was that? Was that Paul?
Paul, yep.
Yeah, great. Thank you. So, and that's the Australian Solicitors Conduct Rules. Thank you. And Pajan?
Yeah, I was just going to say the same thing.
Okay. All right. So that's for the solicitors. What about the barristers? It's called the Barristers Conduct Rules. You can look on the Bar Association of Queensland, and it's known as the Barristers Rule 2016. You may see a reference to the Barristers Rule 2011 or the 2011 Barristers Rule, but it's been updated to the 2016 Barristers Rule. Okay, so why do I ask that? In the context of being law students studying ADR, then it's natural for us to think in terms of what happens in the ADR session from an ethical perspective as being governed by the rules of ethics for solicitors or barristers. However, ADR practitioners are not just lawyers. They might be engineers, social workers, they might be people that are accredited through a dispute resolution centre in dealing with neighbourhood disputes. I mean, what ethical duties do they have? And is it fair that lawyers have ethical duties that other mediators do not have? During the 80s, there was no governing body for mediation as such, or ADR. During the 90s, that started to change with the introduction of the NADRAC regime, or the 2000s. So when you're reading your material, or if you're asked to answer a question in the take-home exam about ethical issues, I guess you need to ask some overriding questions. While we have the Australian Solicitors Conduct Rule or the Barristers Rule, do we need some sort of governing body that oversees the conduct of mediation, and do we need some sort of rule of ethics that relates specifically to ADR practice? Do we need a separate code of conduct for ADR practitioners? And how do the ethical standards that apply for lawyers apply for an ADR session? I mean, there are some practical aspects of it as well. Think of this, for solicitors in practice as a principal, there is an enormous cost associated with professional indemnity insurance. That means that you would need to ask yourself, is the practice of mediation part of the solicitor's practice? In other words, is it covered? Is the mediation work done by a solicitor covered by the professional indemnity insurance? And if it is covered and it's necessary to cover the work done by a mediator, is there counterpart professional indemnity insurance for ADR practitioners who are not lawyers? So if it's cheaper and easier and more accessible for people who are not subject to professional indemnity insurance obligations, as lawyers are, to, as it were, undercut the lawyers, are we driving lawyers away from ADR? And it might then be populated, and I need to be careful with this statement, it might then be populated by people that are arguably less qualified and skilled and experienced communicators. And I'm making an assumption here that being a good communicator is important to being a good ADR practitioner. So these are some of the questions that you might think about when you're reading the material or answering a question in a take-home exam. Also, I mentioned about the ethical standards contained in the Australian Solicitors Conduct Rule and the Barristers Rule. Do we need that in an ADR practice to inspire confidence and to satisfy consumer demand? So what you can do is, for lawyers, have a look at those 2 rules of ethics, and I'd encourage you to do that. You've probably well and truly done that already to some degree through the subjects you've already studied. So that's the Australian Solicitors Conduct Rules and the Barristers Rule. Also, look at the Law Council of Australia guidelines, and there are some specific guidelines in relation to ADR practice. Have a look at that website so that if you're answering a question about ethical obligations and you include a reference to material from the Law Council, then so much the better. So that the guidelines in the Law Council of Australia deal with the process. They deal with issues of ethics and responsibility to do with impartiality, conflict of interest, and competence. Confidentiality is important as well. That's covered in those guidelines, as is the issue of termination of the mediation and recording of a settlement. You've got to be very careful when it comes to recording a settlement. So it may be that your question for the exam talks about how you might react if you're called upon to prepare the agreement and you find that for whatever reason the agreement really is flawed. It's fundamentally flawed. We'll talk more about that tonight in looking at the case law. Also, in addition to the Law Council of Australia, look at the National Mediator Accreditation System Standards, the NMAS, National Mediator Accreditation System. Those standards apply in relation to mediation work, and I'd ask you to look at that. And in the textbook, as I recall, there's some material in relation to arbitration, which is the American Arbitration Association Code of Ethics for arbitrators. Now let's have a look at some case law. The first I want to look at is Mullen's case. Have you had a chance to read it? It's very important. Does anyone want to tell me what Mullen's case is all about?
I'll have a go.
Yes, thank you. Thanks, Karen.
He was acting for a gentleman who had been seriously injured in a car accident a number of years earlier and was consequently quadriplegic. Claims were going on based on a certain life expectancy for that gentleman to continue for, I think it was 20 to 25 years. Whilst the last bit of the settlement was about to be signed, Mullins was told by his client that he had been diagnosed with cancer and consequently had a much less life expectancy. Mullins discussed it with other practitioners at his legal practitioners in his practice and did not tell the other side about the shortened life expectancy. So the agreement as it was went ahead, was signed and agreed upon. The other side subsequently found out about the greatly reduced life expectancy and took both Mullins and also the lawyer involved, both ended up in quite a lot of trouble from the Law Society, or not the Law Society, the, sorry, I forget what they're called.
No, it's all right. It was at that time the Queensland Legal Practice Tribunal. But now it would go through to QCAT, and if not QCAT, through to the Supreme Court. So this eventually went through to the Supreme Court. But you're doing well, Karen. Keep going.
And it basically hinged on whether, through a non-disclosure, whether that breached the obligation that he had. And I'm sorry, I can think of it, but I just can't put it into words at the moment.
Excellent. Does anyone else wish to make any comment about the Mullins case? And thank you, Karen. That was excellent. Well, can I ask this question? If you're in that situation where you are feeling nervous about going into a mediation session because you may have to disclose something which you don't necessarily want to disclose, can you obtain your own legal advice in relation to that quandary? And if so, where do you go? And are you breaching your duty of confidentiality to your client by telling somebody else about your dilemma? What do you think?
I think you can go to the Law Society. Don't they have ethics counsellors for that reason?
Yes, they do. Yep, that's a good move. So you don't feel that that would be breaching a duty to your client by going to an ethics counsellor? Having said that, I agree with you, Paul.
No, I wouldn't. I wouldn't think. I think that's like a. It's sort of like a client. A solicitor-client relationship sort of thing.
All right,
privilege.
So what you might want to do is think about the basis of your argument if you were challenged in those circumstances. I agree with you, Paul. I think you can seek advice from a senior counsellor or another lawyer. But where do you think you would look, in general terms, to come up with an argument to support the fact that you did that and it was appropriate for you to do that? Any thought? We'll go back to basics. If you're challenged about anything or you wish to advance an argument about anything, what sources of law do we have available to us? Hint, the primary and the secondary. Karen says cases and statutes. Yes. So they're the primary sources of law. Would there be any statutes that might assist you in this regard? I would think that you'd go and look at the Legal Practitioners Act. And also there might be some cases. Now, in Mullins' case, we heard Karen say that that's in fact what happened, that the lawyer concerned was concerned and went and obtained advice. So I would have a look at Mullins' case to see if the court made any comment about whether the solicitor was acting appropriately in seeking out that advice. Now, given that this is an ethical issue, where else would you look as the solicitor in those circumstances as part of your justification for your action as appropriate? The hint there, 2 words, solicitor and ethics. So where do you look? I'll make the
in the rules.
Which rules?
Solicitors' rules, sorry.
Solicitors' conduct rules. Perfect. Yes, exactly. And look, a good one to keep up your sleeve is Rule 3.1 for these solicitors provides that your duty to the court overrides the duty to the client. And the duty to the court is widely construed as meaning any process which is judicial or quasi-judicial. So particularly where the mediation is annexed to the court proceedings, that brings it well and truly into the realm of what you're doing is fulfilling your duty to the court, even though it overrides, if you like, the duty to the client. So have those sorts of arguments up your sleeve, ready for to bring out if you're challenged. Okay, so Karen's given us a really good overview of the Mullins case. What else can we say about Mullins? What was the penalty in that case, Karen? Can you recall?
$20,000 fine, and I think a public apology as well.
Yeah, and why? How did the court come up with that figure of $20,000? Do you know?
It had to be something greater than he was paid for doing the case, so that he did not profit from his deceit.
Yeah, I think actually the $20,000 was the fee that he charged for attending that mediation session. So, yep. So that was the penalty there. So remember, there's duties as the client. What about any obligation that you have to your opponent? Are there any ethical obligations there that may be relevant?
Is it through discovery? You have to disclose what you have come across?
Yes, there is that aspect of it. Yep, thanks, Pajan. So again, let's go back to the Australian Solicitors Conduct Rules and think, are there any direct rules that relate to your obligation in communicating with your opponent? I mean, for example, in the Mullins case, by failing to disclose that important information, were you knowingly making a false statement to an opponent in relation to a case? The answer is probably yes. If we look at, again, have a look at Mullins' case and also have a look at the Legal Practitioners Complaints Committee against Fleming, which is a Western Australian decision from the Supreme Court. It's 2006 WASAT at 352. And then finally look at Legal Services Commissioner against Garrett, which is 2009 LPT, which is the Legal Practitioners Tribunal, 12. As I said, now it's QCAT. That will give you some guidance in relation to your ethical obligations in that regard. While we're on Mullins, if I could just mention a couple of other things. Obviously, it's an important case. If we look at Rule 44 of the Australian Solicitors Conduct Rules, you'll see a glossary of terms, and one of them is court. And you'll see that court is actually widely construed as meaning tribunals in some ways, or an arbitration or mediation or other form of dispute resolution. So have a look at Rule 44, have a look at 44.15, the definition of court, and you'll see how widely construed it is. So given that you've got this duty to the court, you need to know what we mean by the court. So have a look at the Solicitors Conduct Rules. So the implications of that definition are very wide-reaching, and Mullins' case would be dealt with under that obligation to the court generally. As far as the barristers are concerned, have a look at Rule 48 of the Barristers Rule, which provides that a barrister must not knowingly make a false statement to an opponent in relation to the case, including its compromise. So the Mullins case was directly referable to Rule 48 of the Barristers Rule. And I've already mentioned Garrett and Fleming. I'll just mention those briefly. In Garrett, the Queensland Court of Appeal noted Mullins and disciplined an instructing solicitor. In that case, the fine was $15,000, remarking that remaining silent during a mediation was, in that instance, practicing with fraudulent deception. So it doesn't take much, and it can be very quick. The consequences can be quite severe. In the Fleming decision that I've mentioned for Western Australia, the State Administrative Tribunal, which is the counterpart of our Queensland Civil and Administrative Tribunal, found a solicitor was acting dishonestly and unfairly during the course of a settlement negotiation. What happened is that the lawyer acted on the basis that a will was validly executed, but it wasn't in that situation. And the tribunal found that the lawyer's participation in the settlement conference was fundamentally different to the adversarial proceedings, and said that a practitioner during these negotiations has an obligation to check and verify information. So it's pretty wide-reaching, and you've got to be aware, I think, of those basic cases and those certainly the conduct rules. Right, any questions about those aspects? And that sort of thing might crop up in the context of some wider decisions that need, or a wider dispute context. How am I going with my promise that tonight would be a short session? Are we doing okay? Not much longer, thank you. There's some good reading in the text material in terms of some articles, and I'd commend those to you. All right, I will wrap it up pretty soon. Are there any questions about the take-home exam yet? Because we'll talk about that more next week. All good? We're ready to go? Okay. The main thing is to have some toolkits ready. Yes, Paul?
You pardon me, you said last week that you were going to put up some previous take-home exams.
I'll do that tonight. Yep.
Okay, thank you.
That's good. I'll put up one. That'll serve as a good discussion point. Yeah.
Sorry, just one other question.
Yes, Paul.
Generally, you know how you have the family law mediators and others. Is their qualification basically the same? You know, the training and that sort of thing that they have to have?
Yeah, actually, that's a really good question, and I did mean to touch on that. So I'm nationally qualified as a mediator, which means, and you should look at that, the obligations imposed upon a person to become nationally qualified and then retain that qualification. But that is different to being a family dispute resolution practitioner. And usually being nationally qualified is a prerequisite to becoming an FDLR. I'm not a family dispute resolution practitioner, but have a look at the obligations imposed on someone who does wish to go that further step and become registered. I can say that I missed a great opportunity. I was doing a lot of family law mediations in the 90s, and then for a while I started doing other things and didn't take advantage of what would have been an easy crossover for me when NADRAC came in, that when the accreditation system came in, you could apply to move across without having to do the extra accreditation, and I missed it which was not like me, I can tell you. But I was busy doing other things. So there's a lot in it. So it's a good question, but I'd encourage you to look at that. And again, that's the sort of thing that may crop up in a take-home exam as well. Thanks, Paul.
Thanks, John.
Okay. All right, so we've got no questions or comments in the chat facility. We'll wrap it up at that stage. I will upload a take-home exam to give you an idea of what you might be looking at. I'm not suggesting necessarily that the take-home exam on this occasion will be in the same format. It could be a completely different format, but at least it gives you some idea. All right, thank you very much for attending. All the best, and we'll see you next week. Bye then.